Thank you very much for allowing me to speak. My name is Raphael Podolsky. I'm a lawyer with the Legal Assistance Resource Center of Connecticut, which is part of the legal aid program. You heard a couple witnesses earlier today from legal aid programs, and I really just came to reinforce some of the things they said. I've sort of been rewriting what I wanted to say to you as I listened to other people talk here. The legal aid programs represent really people on all sides. They represent both mothers and fathers. They represent custodial and non-custodial parents. They represent children. And so we really have an interest in trying to make sure the system is fair to everybody and not to be on one side or on the other side. The real task of this task force is to figure out whether there's need to change the statutes. And that's what I'm going to talk about as distinct from individual incidents. And I think it's important the task force understand that there is a difference between what the statutes say, which provide kind of a structure, and how they get applied in practice. It's important to know both, because you want the statutes to work the way they're intended to work. But it doesn't follow that if there are problems with the practice, the solution is necessarily to change the statute, because changing the statute may create a whole new set of problems that could be worse than leaving the statute as is. In regard to the three pieces that the Commission identified, there are two of those pieces where I think the statute is basically fine, and I hope you will leave the statute alone. And those are the pieces dealing with shared custody and with what I guess I would call undermining the other parent. In regard to the undermining issue, I think the existing statute correctly makes that a factor to be considered. What I think would be a terrible mistake is if somebody tried to write in fixed sanctions for violations, and that's because you don't want to punish the child. The fact that someone may not be supporting the other parent does not mean it's a good thing that the child should be with the other parent. Everything has to be looked at case by case in the whole situation. The statute as it exists does that. The shared custody issue is a difficult issue because I think most of us would agree, as the last speaker said, that in the ideal world everybody would like shared custody. But when you create a legal statutory presumption, you are changing the results of what will happen by making it the starting position and by throwing a burden of proof onto anyone who wants to change that. The reality is shared custody works best when you have two cooperative parents. And in those cases, they can very often work that out themselves. You don't actually have to litigate the issue at all. When you don't have that, there are numerous circumstances that we've experienced where shared custody would not work and would be a bad idea. You have situations with domestic violence, but much lower levels, just plain bullying or patterns of insulting people or dominance in the sense of one person asserting authority over the other in a way that intimidates. Let me try and be quick. We have a lot of cases where one of the parties doesn't show up. Parties aren't married to each other, may never have lived together. We have their fathers who've never seen their kids. So you've got this. The statute has to cover all that. The area where I think you might want to look more is this whole discussion of GALs. An earlier witness from legal aid suggested some possible changes, and you may need to do further study on things like how cost impact can be handled. I'm very glad you heard the previous speaker because I think it's important to understand that there are two sides to this and that you need to see why GALs are needed for the court, for this system to function. You can't just leave it to the judges to work without any information other than the two parties. Thank you very much.
Thank you. Are there any questions?
I have a question. On number 2 of your written testimony, you talk a little bit about noncompliance and that you believe the statute is good the way it's written. But listening to people's testimony today and knowing, a lot of people go into court and just get a slap on the hand, do you have any other suggestions of like what the courts could do? Like not an automatic cutoff of custody, as you say, but any other suggestions?
Well, there's all sorts of things that courts can do. They can take away visitation time or add visitation time. It depends what we're talking about. Is the conduct that is being complained about? Because that kind of essentially undermining the relationship with the other parent can be done in a shared custody situation. It can be done in a single custody situation. It can be done by the person who has custody. It can be done by the person who has visitation rights. There's no one thing that is happening. And so whatever this, I would think initially, you would start by saying, stop doing this. Assuming that you're able to sort of evaluate the credibility of everybody and determine who is giving you a better and more accurate picture. But assuming that a judge would conclude that this is in fact happening, and then if that doesn't work, then people can devise different ways. I mean, maybe you have makeup visitation if somebody has obstructed. Maybe you require therapy in some of those circumstances. But part of this is you have to keep track of what's best for the child, and what's best for the child may or may not match up with what's best for either of the parents. And so it's just more. All I'm saying is it's more complicated. I think the court has really a full creative range of remedies, with the ultimate goal of getting compliance with the orders and with the statute.
Okay, so, and I don't think we're talking about the typical, you've missed a couple of visits, let's go to therapy. You have a parent that isn't even taking the child to visits, and you're going to order therapy. So now we have a parent who's not taking the child to therapy. We're in court for the 6th time. What would your suggestion be then?
I can't really answer the question without. I would have to know a lot more about all the circumstances. I'm not saying that you would never change custody, or that you would never suspend visitation, or all those things are within the range. I think the court should do what is appropriate under the circumstances, bearing in mind what it is the person is doing in violation of orders, and what will be the consequences for the children of different forms of enforcement. And I'm sorry, I just can't give you a specific answer.
But that's fine. We were just looking for suggestions, and
I think the court. I guess what I'm saying is, when I distinguish between the structure and the application, it seems to me the statute alerts the court to the issue, expressly says the court can deal with it and should consider it in making its decisions, and that you don't have to go beyond that in terms of putting something into statute as to what those options may be for the court. That's really what I'm saying, that the discretion is there and you want the discretion to be there, and these matters are so individualized that you don't want to say, well, here, you got 3 things, Judge, you can do one of those 3 things, and that's it.
We're not looking for that.
No. Mr. DeTono. Then never mind.
I was really just going to talk about, you're saying don't be prescriptive, don't lay out certain options for the court and statute. I just was asking for you to just keep going on that and give us a little bit more information on why you feel that way.
Okay.
Madam Chair.
I'm sorry.
Okay. Thank you. I have a question for you regarding the best interest of the child is not to have sanctions against the parent who is the offender, who's not delivering the child to the parent, who's, not following court orders. So what do you feel about financial sanctions for that parent?
I think in an appropriate case there may be financial sanctions. I guess what I'm trying to say is I would treat all possible sanctions as being on the table, but I would not push particular sanctions in a way that's sort of designed to get the court to say, oh, I really kind of have to do this if this event occurred, so that financial sanctions are a possibility.
One thing that I am strongly against is incarcerating parents, because that's definitely not in the best interest of the children either. But that happens when a parent doesn't pay child support, or, I guess most cases it's the father. If he's not paying child support, they're incarcerated. So can you give how do you feel about that position? So we, as a court, if a parent is behind on child support, I know a lot of times I've gone to the court and I've watched different hearings, and they do have a lot of flexibility with some of the judges. They'll, okay, you have to pay $20 a week for the rearage, and they don't put them in jail. So maybe it's the real extreme cases. I've never seen it firsthand, but I've heard stories that they are incarcerated, which is definitely not in the best interest of the child. So if you have the other parent who is blocking access, not following court orders, and there's a lot of slap on the hand, how are we going to deter those parents? What's your opinion on that?
There are sort of two halves to the question, and let me try and answer both halves. First, I should say I'm sort of speaking from my own personal view. I don't want to tell you that I'm necessarily speaking for what everyone in legal services thinks. In regard to incarceration, I think that we right now have over-incarceration for non-payment of child support, and so when you ask the question, it may well not be in the best interest of the child, and there may be some circumstances, extreme circumstances, where that must be done. In theory, incarceration for non-support, for failure to pay child support, is based on, it has to be willful and based on the fact that the person does not have the resources to make the payments now. When that's the case, incarceration may be appropriate. When in fact the person doesn't have the resources, incarceration may be inappropriate. So on that half of the question, I think, my view would be we should try and minimize incarceration as a sanction, if at all reasonably possible. In terms of whether, it seems to me that there are things beyond, the only choice is not major sanction versus a slap on the wrist. That's the whole point of saying there can be all sorts of graduated sanctions, and that the more, certainly if someone if it's repeated, or if it's a long history, or if there's good reason to believe that it is deliberate and willful, I mean, that would generate, I would think, a greater kind of sanction than would something that happens once and is sort of, it got people upset, but it's not typical of the whole pattern. So I'm stuck saying I can't really answer the question in the abstract, but I think there's plenty of capacity in the court system to have a whole range of responses that take into consideration, within the limits of reason, what is best for the children, and presumably what's best for the children is for the parents to obey the orders that the court has issued, because in theory at least the orders of the court are for the best interest of the children. So it all sort of fits together, but I only get concerned about this when people talk as if one witness you had early had like a whole sanctions structure of, this for the first time, this for the second time, this for the third time, the end being give the kid to the other parents. And I'm thinking, this isn't like a grocery store where you're just buying and selling kids. It may not make sense to give the kid to the other parent, but it may make sense that other parent should be bringing the kid to visitation on time. So you just have to think those things through, and you don't want to write something into the statutes that's going to push judges the wrong direction.
Dr. Hurwitz.
I appreciate your thoughtful comments on the proposed statutory changes. I'm just wondering, in the one of the three where you actually recommend some change, as the one about the role and the procedures for the GAL, and you talk about making the system less costly, but I wasn't clear how your recommendations would actually achieve that.
Yeah, I don't think that we,
unless you want more cases handled by your agency.
I don't think we necessarily know. One of the things that has been brought up by some of the legal services attorneys is that over time, the Family Relations Office has basically lost funding and lost staffing, and that there's a certain sense in which a number of the cases that end up with GALs might well, say 5 or 7 years ago, have been handled through conciliation and mediation at Family Relations. And so that wouldn't solve a problem for any particular person who ends up with a GAL and there's a large bill, but it might reduce the number of referrals if we looked at the state budget and made sure that the level of staffing of Family Relations was at least what it was 10 years ago, and ideally was better. Whether that's practical to do or not, given the state's budget situation, I don't know. So that might be one kind of thing that could be done. I think we have thought that it would be helpful if there are I'm told that in some states there's fairly specific overriding sort of standards for GALs that are formally adopted by the judicial branch. It doesn't have to be in statute, but are formally adopted, and that in some places, and I guess in some of the courts in Connecticut, individual courts or judges use checklists to say, here, I'm checking off of the things I expect from the GAL. So I think some specificity there, and for example, because a big issue is how they apportion their time between seeing the child and doing other kinds of things. And so maybe there are ways that could be better identified. Maybe the courts should be more careful in evaluating whether they should, for example, put a cost cap on at the time they assign a GAL, although then you have competing aspects because you also want the GAL to do a good job and not essentially sit around and do nothing. But on the other hand, you don't want to bankrupt parents. And so those are some of the kind of things that I think should be looked at. And it's the reason when I was testifying, this was not in my written testimony, but having listened to so much testimony here today, and a lot of it focused on GALs, it may be that your timeline for producing a report is not adequate for your doing a full evaluation of how the GAL system should be looked at. So it may be that you end up with a couple of recommendations, but also a recommendation that it might require some further study. Because the session starts in a month, and I don't know whether you are really ready and whether you have enough. You have anecdotal things, but it's always, as with the previous witness, when somebody who is not part, I'm assuming he's not part of an organized group, comes and says, you need to hear that I had a lot of success with my GAL, and so we just shouldn't. And the reality is, in family matters, there really are two sides to everything. They're not equal. I'm not saying everybody's right. Sometimes one person's 100% right and the other person's 100% wrong. But there also may be variations where one person is 60% right, and but you ought to hear that other 40% from the other person so that you can sort of evaluate the whole picture. And when you only hear it from one side, it can be difficult to know how exactly right you have it. And I really wish that there was sort of organized groups on the other side, victims of domestic violence, for example, just so you would hear what they have to say without my being able to say who is telling the truth and who's not telling the truth.
I think your point about family relations is really a valid one, and I have seen an increase in the percentage, in my opinion, of cases that have GALs appointed. And I think a lot of times it comes from that very problem. And I think that sometimes it's almost like you don't agree, you're getting a GAL. I really think that your point's very valid. I think that there could be better funding to avoid taking this down that road.
And the reality is that for the court system to function at all, they need people to find ways to work out their disputes as much as they can. The real high conflict, there's maybe no choice to be in front of the judge and letting the judge make a decision. And I also understand some people's concerns with intimidation. It doesn't necessarily work to have people being intimidated into accepting an agreement that they really don't want. But we see it in all areas of the law where you need to devise ways to really push people to see if they can't find some acceptable middle ground that they can live with rather than, in a sense, roll the dice and go in front of the judge. And again, I don't think it's appropriate for GALs to be threatening people, but I also do think the system needs to find ways to push people towards reasonable, acceptable compromises.
And I think
that's very difficult in high conflict situations.
Yeah, and one of the things we heard was about early intervention programs with mental health professionals where if couples could have some counseling in the beginning, it may eliminate the need for this to become a high conflict case. And we have, the Children's Law Center does some of that, but funding there again is difficult. So I appreciate those comments because I do think they are absolutely essential, that we need some help for these people early on to avoid this.
These are very, very difficult situations, and people, it's very difficult. And unfortunately, the children are in the middle of it.
Right. Representative Gonzalez.
Thank you, Madam Chair. Thank you very much for being here, but I think that, I see you almost every day here in this building. And I think that I would like to say that thank you for, on behalf of those people that you're always here to help, and good ideas, and I always look up to you because of that. So thank you very much.
Thank you.
Knowing that all these complaints about the guardians and Litems, and some of the people are complaining that only a few. There is like a clique. It's only a few guardians in Litem. They are getting, the big cases, making the big dollars. Do you think that there will be a good recommendation that maybe we can have a list of all the guardians in Litems in different court, and people will pick their guardians in Litems, because that way you can say this is only a clique. The people, they went through the training, they are not getting any cases. It's only a group of guardians in Litems. Do you think that would be better if we can maybe have that list and let people pick a guardian in Litem from that list?
I have to tell you, I'm a little skeptical of that solution. Some of this comes from, as you've heard, that people have very different views of who's a good guardian at Litem, who's not a good guardian at Litem. The difference, as a general rule, the attorneys are going to know a lot more about the guardians at Litem than a pro se litigant would know. And the list, this whatever 1,000-person list or whatever it is not really a certification that the guardian at Litem is necessarily good or has all the right skills. It's a certification they went through a brief training program. So I guess first I would say, when you have lawyers on both sides, if they can work out who's going to be the guardian at Litem, I don't see any reason why you wouldn't just say that's fine. If the problem for litigants picking a name off a list is most litigants don't have any idea who these people are. So they don't have any way to distinguish good and bad on the list, experienced or inexperienced, other than a name. And so I'm not sure that provides a tool for doing it well. One of the reasons I think that sometimes particular guardians at Litem, I don't have the same conspiracy theory that some of the witnesses have had. But I do think it's true that people who are in the courts frequently see who does a good job and see who doesn't, and they're also depending. If the judge has if you're in a situation where a judge has to pick a guardian at Litem, if the judge has any knowledge of the case, he may be in a position to know that some guardians at Litem, say, are better working with younger children than older children. You don't know that if you're picking a random name off of a list. So I don't know. I can see some benefits to doing it, but I can also see a lot of problems, and I worry that I think I would rather see a situation where we have better evaluation of guardians at Litem. That was one of the proposals, that there be post-hearing evaluations that litigants are able to participate in, that we try and actually gather more information about how guardians at Litem in fact perform. I'm sorry, that's a long. You were actually asking me a yes or no question.
No, it's okay. No, it was a good answer. Thank you.
I'm just going to jump in to say such a list does exist, and it's on the judicial website, and it's available to everybody. There is a list of everyone who has gone through the training program. They are identified by which judicial district that they are willing to serve in, and that's readily accessible on the judicial website. And if both parents agree to any name, I can't say every judge would always appoint them, but for the most part, I can't imagine that a judge would not appoint someone that both parents go in and ask to have appointed, whoever it is.
Right, but I think the situation that Representative Gonzalez is raising is sort of the unrepresented situation where at least one of the sides is unrepresented and they really have no knowledge. And so then the question is, would you want to throw that into sort of a random rotating list? But people could end up being very unhappy with who they get off that kind of a list. So that's why I don't know if it's a solution to the problem.
Thank you. I might get a little slack for this comment, but I find too that the guardian ad litem's an attorney for the minor children that start out at state rates and being a poverty attorney, once they get the reputation of being good, then they start getting paid, assigned to the high price cases and don't take state rates anymore.
I think that's probably true, but I think also some people don't take state rates, but will do pro bono work instead because of not just billing, but contractual differences of opinion with the state rates contracts. So I know that's the case for people that I know. I have to say, I think that we definitely should have some discussion amongst us about the evaluation. You know, that you brought it up, someone else brought it up. Judges, when you have a trial in front of a judge, you get a form to fill out to evaluate them, and I think that's probably something that's valid in this instance too. Maybe something could be developed, you know, that could give people an opportunity to comment.
We would agree with that.
Thank you.
Thank you very much.